Hey, everybody. Estate planning attorney Paul Rabelais here. Title of this live stream, The Relationship Between the Capital Gains Tax and Estate Tax. So the word tax is in there twice in the title. So if you're not a big fan of paying taxes, or if you're not a big fan of paying a lot of taxes, then this live stream is probably for you. So a lot of confusion out there. There's confusion anyway in general, but because the laws are changing in a couple of years, there's an extra layer of confusion. And we're going to sort it all out here this evening. So welcome, Larry. Welcome, everybody else. Tell your friends, tell your neighbors. We got it going on here, live stream, a lot to talk about. I'm going to go through, when we talk about the relationship between the estate tax and the capital gains tax, we first have to define what is the estate tax and what is the capital gains tax. And then we're going to start talking about how all that affects this sunset of the Tax Cuts and Jobs Act of 2017. The sunset will occur on January 1st of 2026. We'll talk about strategies for smaller estates, strategies for medium-sized estates, and strategies for the larger estates. And I realize small, medium, large is a relative term, but I'll be defining that throughout the live stream. So I got a lot to share with you. Okay. Excuse me. As always, the reason we do the live stream is all about the chat. So always like to see you contribute to the chat, say hello, share a comment, share an experience, ask a question, keep it positive. The way this live stream goes is I've got some information I want to share with you. After I share that information over the course of maybe 30 minutes or so, we'll go to the chat. I'll look at them one by one, and where it's appropriate, I'll give you an answer, give you my 2 cents, and kind of moderate that chat discussion. So looks like we got the usuals here. Always great to see it. We've got Larry. We've got Ann with her funny. Those emojis always make me laugh. Johanna. And so great that all of you are saying hello to each other as well. So, all right, let's jump right in. First, and if you've been on some live streams, the next minute or so is going to be kind of redundant. What is the estate tax? And I was kind of doing a little prep for my live stream today, and I was looking at some of the IRS pronouncements and how the IRS defined the estate tax, and it kind of rubbed me wrong. The IRS says that the estate tax is a tax on your right to transfer property at your death. You know, it just doesn't sound good. A tax on your right to transfer property. You know, for whatever reason, that just rubs me wrong, but that's what the IRS says the estate tax is, a tax on your right. Great. You've worked hard, you've saved up, and now you have to have this right to transfer property to the people that you leave behind. And so the IRS is going to assess a tax on it. Fantastic. Now, but when we get into the nitty gritty, I tend to oversimplify things. I tend to just say, hey, it's a 40% tax. Yes, we have an estate tax exemption. We'll talk about that a lot on the live stream for people who pass away in 2024. It's a big number, $13.61 million. So if somebody dies, the first $13.61 million that they have is exempt from the estate tax. I generally say everything someone has in excess of that exemption, which is going to be cut in half in 2026. More on that in a minute. But everything someone has in excess of that exemption is taxed at 40%. It's not the first dollar of the taxable estate is not taxed at 40%. The first dollar of the taxable estate is taxed at 18%, but it graduates and it goes up to 40% fairly quickly. So when the taxable amount exceeds $1 million, so someone dies, they have $14.61 million. All of what they have in excess of that $14.61 million, which is $1 million more than $13.61 million, everything in excess of that $14.61 million will be taxed at 40%. The first $1 million of the taxable amount is taxed at anywhere from 18 to 40% as graduated. All right, so somebody might be saying, well, what does the IRS count for purposes of the estate tax? And really, they count everything you own. So whether that's cash, bank accounts, checking, savings, CDs, securities, stocks, bonds, mutual funds, real estate that you own, real estate that's in an LLC when you own the LLC, life insurance on your life. There's some exceptions, but if you own the life insurance and you are the insured, that's part of your estate. Just as a side note, some people create these irrevocable life insurance trusts where they create a trust typically for their children, and that trust purchases life insurance on the life of the parent or parents. And then the parents pay those premiums by making a gift to the trust for the children. And then under that scenario, when the parents die, the life insurance is payable to the trust, and those life insurance proceeds are excluded from the taxable estate of the parents. But generally speaking, most people, they own their policies, they are the insured, and so that death benefit is subject to the estate tax. If you have assets in a revocable living trust, those assets are part of the taxable estate. Annuities, business interests, vehicles. Some people mistakenly believe, and I can back up these statements when I say some people mistakenly believe, because every year I have thousands of conversations with people all around the country who try to tell me what they think they know, and I have to correct them politely, of course. And it is a confusing area, so it's not like they're an idiot for saying something wrong by any stretch. Sometimes I say things that are wrong. But some people mistakenly believe that if an asset is excluded from the probate of a person, then it's not part of the estate for estate tax purposes, and that's just wrong. So the estate for estate tax purposes includes things like IRAs, even though they have designated beneficiaries, investment accounts that have transfer on death beneficiaries, bank accounts that have payable on death beneficiaries. So all that, if you own those assets when you die, it's part of your estate subject to the estate tax. The way it all gets calculated, it gets reported when somebody dies with a gross estate that exceeds the applicable exemption amount, 13.61 million for 2024, excuse me. Then all of those assets have to be valued to the extent that it's real estate or a business interest. Those things have to be appraised. It all gets reported on what is called IRS Form 706. Earlier in the week was the deadline for filing the income tax return, which is completely separate. That's IRS Form 1040. The estate tax return, IRS Form 706, due 9 months from the date that the person died. Some people think mistakenly it's due April 15th of the year after someone died. That's not true. It's due 9 months after the date of death. Married couples have some special rules. There's some special estate tax rules for married couples. The primary rule for married couples is called the unlimited marital deduction. Generally, what it allows married couples to do is, regardless of the size of the estate, it can be arranged so that no estate tax must be paid when the first spouse dies. All the tax that is due based on the spouse's exemptions and the amount that they may have in excess of those exemptions, it can be arranged with proper planning so that no tax is due until after the surviving spouse passes away. All right, so that's a good enough for now. Since we're not focusing on just the estate tax in this live stream, that's probably a good enough. Here's what the estate tax is. All right, next let's do a quick intro on the capital gains tax. A lot of misconception there. Capital gains tax is the tax on the profit that someone makes from the sale of an asset. Probably the key thing to remember, and most of you may be aware of it anyway, that there is no capital gains tax until an asset is sold. Was having a conversation yesterday with a retired dentist who had done very well. And he's like, Paul, I did something good. Years ago, I bought a bunch of Microsoft stock. And I don't want to give it to my kids. I don't want to give it to my grandkids, because when I give it to them, they'll have to pay a bunch of capital gains tax. And he was like, my kids are all doing fantastic. The gentleman was about 80 years old. And he says, my kids don't need it, but I really want to avoid tax. So I had to correct him after a few minutes. I said, when you make this gift of Microsoft stock to your kids, they're not going to have to pay capital gains tax when you gift it. They'll only pay capital gains tax, when and if they sell it. And even then, he kind of realized, so if I give this stock to my kids and they never sell it, then all that appreciation will go untaxed, because it'll get a step up in basis when my children pass away. We haven't even really talked about the step up in basis yet, but I said, yep, you got that right. Okay. Now, while the estate tax kind of top rate is at 40%, the capital gains tax rate, at least on the federal level, tax rate is 20%. So, all right, while we're talking capital gains tax, let me hit the step up in basis rule, because it's really important when we're talking about the relationship between the estate tax and the capital gains tax. Really need to be aware of the step up in basis rule. Pretty simple. Appreciated assets that are included in the estate of someone dies get what's called a step up in basis, which is a really good thing. In fact, some people think it's like they don't even believe it's true because it's a big tax break, although you got to die to get the big tax break. But like my gentleman yesterday, who, I don't know, he had several $1 million of Microsoft stock and he bought it, let's call it at $5 a share. I don't know what Microsoft is trading for today, but it's a number that's a lot larger than five. If he were to sell that stock, he'd have a pile of capital gains tax to pay. But if he holds on to that stock and he leaves it to his kids, then when he passes away, maybe somebody can help me in the chat so I'm not way off base here, but I'm just going to come up with a number of, let's say it's worth $200 a share. I have no idea. Haven't looked at Microsoft's stock price lately. But if he bought it for $5 and if it's worth $200 today and he sells it while he's alive, that's $195 of capital gain. That's subject to the capital gains tax. However, if he dies and he leaves it to his kids or leaves it to whoever, when he dies owning that appreciated asset, then the basis changes. The capital gains tax basis changes from that original $5 acquisition. Microsoft $3.99 today. Thanks, Michael. So it's even worse. Yeah. Bought a share for $5 today. It's let's call it $400. If he sells that stock while he's alive, $395 of capital gain, a bigger pile of capital gains tax. But by dying, and if that stock is in his estate when he dies, all that capital gain goes untaxed. A new capital gains tax basis is established, and the basis is the value on the date that he dies. Let's say when he dies, it's worth $400 a share. That's going to be the new basis. That $395 of appreciation just completely goes untaxed, never to be taxed again. So that's a big deal. Now, what this is all about is, geez, well, great that it's in your estate and great that you get a step up, but what if the fact that it's in your estate causes a 40% estate tax to be due? That's the relationship between the estate tax and the capital gains tax that we'll be talking about here in a few minutes. All right, so we're still in the setting the foundation here, but we're about 2/3 of the way through. We've talked about what the estate tax is. We've talked about what the capital gains tax is. By the way, on the capital gains tax, if you do live in a community property state, you get an extra tax advantage when the first spouse dies. All of the community property, not just the first spouse dies, half of the community property, all of the community property, both spouses share the community property, gets a step up in basis when the first spouse dies. That's a pretty big deal. And I think the reason for that is a long time ago, the husbands were the ones that were working, and most of the assets accumulated in the husband's estate. And then often the husband died first. And so since the bulk of the assets were in the husband's estate and he died first, the bulk of the assets got a step up in basis when the husband died. And so I think that's the reason why years ago they just said, well, if for community property states, let's just make, even though the husband worked and the husband earned all the assets, I know it's not like that today, let's equalize that for community property states, because the husband only owns half of the community property. And so they said, well, let's just allow those both halves of the community property to get that step up in basis when the first spouse dies in a community property state. So anyway, extra nice little advantage. And there's some decisions that married couples make while they're alive when they're arranging their estate plan that surviving spouses make within a short period of time after their spouse dies. There's some decisions to be made as to can things be done so that after the first spouse dies, all of the assets get included in the estate of the surviving spouse, so that all of the assets get another step up in basis when the surviving spouse dies. Just realize that's the case. And one last point on the capital gains tax is the carryover basis rule. So for example, if my dentist that I spoke with yesterday bought Microsoft for $5 a share and today it's worth $400 a share, we're going to talk about gifting here in a minute and how some people can really save some all-around tax dollars by doing some gifting. But quite frankly, if the dentist with the retired dentist with the Microsoft stock at $5 a share and it's worth $400 a share, and he's like, I got to get some of these assets out of my estate to avoid the 40% tax. But if he gives away those shares of Microsoft stock before he dies, he gives those shares to his children, for example, or grandchildren, or anybody, then they're not going to get that step up in basis goes away. Those people that he gives the stock to during his lifetime get what's called a carryover basis. Their basis will be whatever his basis was. So if he gives a share of stock during his lifetime to his son, and he bought and dad bought it for $5 and now it's worth $400, son's basis in that stock, because he received it as a gift instead of an inheritance, son's basis in that stock is going to be $5 a share. So whenever that son sells it, he's going to pay massive capital gains tax. Now if the son holds on to it, but never sells it, passes it on to his children, for example, then it'll get a step up in basis when the son dies. But the son's got to hold it a very long time to be able to do that. Okay, so that's a quick one on the step up in basis. So we've gone through estate tax, capital gains tax. Now I want to get the rules straight on this sunset of the Tax Cuts and Jobs Act of 2017. This is where a lot of people are confused. And again, I know a lot of people are confused because I've had lots of discussions with people all around the country. I do have a national estate planning law firm, and if any of you are interested in getting some help by me and my staff to get your estate in order, you can click a link in the description to the video, and that'll start the process of requesting a Zoom meeting that we could have and have a discussion about trying to figure out what's most important to you and the easiest way to get there. All right, so I've had lots of those discussions with people all around the country, hundreds of conversations about this specific issue of the sunset of the Tax Cuts and Jobs Act of 2017. Everybody's confused. And what it has to do is, yes, I said earlier, for people who die in 2024, maybe it may sound kind of insensitive about death and, dying this year, dying next year, dying in 2026. But you know what? The only way I know to deal with this is to be blunt. So I'm going to be blunt, and I'm going to talk about people dying this year and next year and the year after. And it's the only way I can really teach the material. But there's the estate tax exemption for people who die in 2024, $13.61 million. It'll go up again in 2025. Nobody knows what the number is because it gets adjusted for inflation. We'll know that number towards the end of this year. Maybe it'll be around $14 million or so next year. And then in 2026, it's going to get cut in half. So if it's $14 million next year, be cut to $7 million in 2026, but plus an inflation adjustment factor. For purposes of our examples, let's just say in 2026, the exemption is $7 million. And that's because the Tax Cuts and Jobs Act of 2017 is expiring. And because that act is expiring, we're going back to the way the law was prior to the Tax Cuts and Jobs Act of 2017, which was a $5 million exemption adjusted for inflation. All right, so here's where a lot of people get it wrong. And I'm going to use several examples as I'm talking here. Let me give an example of a lot of people are contacting me. And again, the numbers are relative. And look, I'm going to use the word small, medium, large estate. And I realize some of you may think a $2 million estate is super large. And I know some of you may think a $20 million estate is, it's okay. But I'm just going to throw out numbers. They may not apply to you. Maybe they do. But again, I'm not going to be sensitive to the fact that you may or may not have less or more than the numbers that I'm referring to. I'm just going to tell it like it is. All right. So the problem people are assuming incorrectly today. Some people are telling themselves something like, wow, Paul, you're telling me the exemption is going to come back to $7 million in 2026. I'm like, yeah, somewhere around there. And they're like, Paul, you're telling me the exemption right now is $13.61 million. Yeah, that's what I'm telling you. So then they instantly just come to the conclusion of, Paul, I've got it. I'm going to get $5 million out of my estate while I have this $13.61 million exemption. And I'll still have another $7 million that I can leave estate tax free when I die. Well, ding dong, you're wrong. And I had a teacher that used to say that, and it just came to me. So, all right. So let me cover that. Um, and before I cover that, let me also talk about what I'll call as the anti-clawback rule. Again, a bunch of people are thinking it's almost 2026. The estate tax exemption is cut in half. We got to do something in order to save a whole bunch of taxes. But first, let me talk about the anti-clawback rule. And this really only applies to the really wealthier people. So the anti-clawback rule says that an individual or an estate won't be taxed on gifts that were tax-free and made before 2026. Let me give an example. Let's say someone gives away $13 million to their children, grandchildren, whoever, a total of $13 million this year in 2024. Well, based on the anti-clawback rule, then even though the exemption comes back to $7 million in 2026, the IRS or the government isn't going to claw back that $13 million gift and try to impose some tax because the exemption subsequently was changed back to $7 million. So if you make those large gifts this year and next year, you're good based on the anti-clawback rule. Now, let me get to the rule I really want to talk about is what's going to be people's exemption moving forward, particularly for those people who are thinking they should maybe give $1 million or $3 million to their kids now before January of 2026. So here's the rule that's probably the most important rule that I'd like to leave you with. Starting on January 1st, 2026, a deceased person's federal estate tax exemption will be the greater of what they had previously gifted under the exemption at the time of the gift, or the amount of the exemption in the year of their death. So I'm going to give you a couple of examples. And let's just, for purposes of all these examples, let's assume in 2026 there's going to be a $7 million exemption. And really, while appreciation of assets after they're gifted is a significant thing, I'm just going to forget about appreciation of assets from now till 2026. And yeah, I could factor in some appreciation, and there is some estate tax savings that results from people making some gifts now, letting those assets appreciate outside of their estate after they're gifted. But right now, I'm just going to forget about appreciation just to keep the math simple and allow you to understand the principles. So my first example is, let's assume a $13.61 million exemption here in 2024 and a $7 million exemption in 2026. And let's say, big number, someone has a $20 million estate and they do no gifting this year and they die in 2026 with their $20 million estate. Well, their exemption will be the greater of the exemption that they used during their lifetime. They didn't use any, or the exemption at the time of their death. They died in 2026. So their exemption is $7 million. So they died with $20 million. Exemption was 7. That makes $13 million subject to the estate tax at about 40%, $5.2 million of tax. All right. Now let's use the anti-clawback rule to change the facts a little bit. Same $20 million guy died in 2026. But in 2024, he had given $13.61 million away. And when I say gave it away, he transferred stock or gave a business interest or gave away land. And let's say he gave it to his kids. Maybe he had 2, 3, 4 kids. So the total amount that he gave in 2024 was $13.61 million. So he had 20 million. He gave away 13.61 million. So he only had 6.39 million. I say only left, but you know what? He felt like, I'm going to give away $13.61 million. And really, when you give it away, you give up control. But he felt like he could live off of the remaining 6.39 million. So he did that. And so by doing that, he saved a lot of taxes because of the anti-clawback rule. His exemption was the greater of the exemption that he used from gifting. So $13.61 million he gifted this year. Exemption is the greater of that number or the exemption when he died. The exemption when he died was $7 million. He died in 2026. So he got to take advantage using the anti-clawback rule of the $13.61 million. And the previous example of the $20 million guy who didn't do any gifting, who his estate wound up paying $5.2 million of tax. Well, this guy, but $20 million guy who did take advantage of the anti-clawback rule by giving away $13.61 million in 2024, when he passed away, just that extra 6.39 was subject to estate tax, wound up paying about $2.55 million. So that's the gifting versus the no gifting. No gifting, $5.2 million of tax when he died. Take advantage of gifting in the anti-clawback rule. Had to make a large gift to be able to take advantage of it. Had to make a large gift of $13.61 million. But the end result of the tax being paid was $2.55 million instead of the $5.2 million. Okay, so that's for the larger estates, that can take advantage of the anti-clawback rule. Let me give you another example, a little bit lesser estate. These are the conversations I'm having all of the time. Yes, I've had a few conversations with people in the 20 million, 30 million, 40 million and above, but more of my conversations have, especially when it comes to the sunset of the Tax Cuts and Jobs Act, more of those conversations have been with people in the, 7, 8, 10, $12 million range, which is a nice nest egg for sure. So let me give an example of someone who has $12 million who says to themselves, you know what? I'm going to beat the IRS. This exemption in 2026 is going to be cut down to $7 million. So I have $12 million. What I'm going to do, and this is where somebody's making a mistake, or at least, I don't know if it's a mistake, may not be a mistake, but they're just not fully informed. So the $12 million person says, you know what? I'm gonna beat old Uncle Sam at his own game. $12 million guy says, we got a $13.61 million exemption coming back to $7 million in 2026. I tell you what I'm going to do. I'm going to go ahead and donate $6 million of my $12 million to my descendants, children, grandchildren, whoever. And I'm going to do that in 2024. And I'm going to keep $6 million to live on. I can live on $6 million, no big deal. So I have $12 million. I'm going to beat Uncle Sam. I'm going to give $6 million away. I'm going to be left with $6 million. And that guy thinks he's going to save a lot of tax because of the sunset of the Tax Cuts and Jobs Act estate tax provisions. So he dies in 2026. The problem is, you apply the formula. What's his estate tax exemption? It's the greater of the amount he gifted during his lifetime using the larger exemption. He gifted $6 million in 2024 when the exemption was $13.61 million. So under the first part of the formula, it's the greater of what he gifted. He gifted $6 million, or the exemption when he dies. He dies in 2026. The exemption $7 million. $7 million is his exemption. But by making the gift of $6 million in 2024, he used up $6 million of his $7 million exemption. He dies with $6 million. He only has $1 more million available of his exemption to use. So $5 million will be subject to estate tax. There'll be about a $2 million estate tax bill. But really, that's no tax savings over the guy with $12 million who doesn't do any gifting. And he dies in 2026. And sure, exemption $7 million, the greater of what he gifted. He didn't gift anything. Or the exemption when he dies, $7 million. He dies in 2026, dies with $12 million, $5 million subject to estate tax, $2 million of tax. So the people who are out there thinking they're going to, quote, beat the system by gifting 1 million, 2 million, 3 million, 4 million, 5 million, they're really not beating the system. They're using some of the $7 million plus, depends on when they die, exemption. They're using up that $7 million exemption while they're alive. The only people who are really benefiting from the anti-clawback rules and the sunset of the Tax Cuts and Jobs Act are those really wealthier folks with 20 million, 30 million who can afford, because who can financially swing it to really take advantage of the anti-clawback rules and go ahead and max out and use that $13.61 million exemption while you have it. And so, there's a big difference in tax savings between the person who gifts the $13.61 million versus the person who gifts $5 million. So, all right, hope you're starting to kind of get some of that. So now let me apply all of that. In fact, I will say that $12 million guy who gave away $6 million, he didn't owe any tax on the gift because he used some of his $7 million exemption. But the problem is, by giving away $6 million, I didn't define what he gave away, but if he did give away some appreciated assets, on the gift, that's a carryover basis. So that family may have wound up paying more overall tax because a significant gift was made. It really didn't save any estate tax, but it caused a lot of unnecessary capital gains tax to be paid because of the carryover basis principle on gifted assets versus the step up in basis on inherited assets. Okay, so let's talk about some strategies here. Strategies for relative term smaller estates. All right. By the way, I think there's probably a like button somewhere. I see we're at 25. Let's see if we can get that up to about 50. That'd be fantastic. Make my day. So make sure you hit the like button. All right. Smaller estates. And small is a relative term, but let's call it those estates that are under $5 million if you're unmarried, or $10 million if you're married. Still a very healthy estate. Still, you're in the top. I don't know what you are, 1-2%. Who knows? I don't even know. I haven't looked at the facts, but nonetheless, I'm going to call it the smaller estate for purposes of talking about the estate tax. $5 million or less if you're single, $10 million or less if you're married. That's and you probably have a mix of assets. You probably have a home. It's worth, $500,000, maybe $1 million. You've got some retirement accounts. You probably have a brokerage account with some appreciated, stock in there. So that strategy, that best strategy may be to keep all of those assets in your estate. Because if you know, and nobody really knows, but if I'm just for fun, if you knew there was going to be no estate tax when you died, then I'd say keep it all in your estate, because when you die, all of the assets in your estate get a step up in basis, which is a great thing. There's no real reason to remove assets from your estate for estate tax purposes if there's not going to be any estate tax when you die. Now, we don't know what the estate tax is going to be in 10 years. We don't know how much your estate will appreciate or depreciate. It'll probably grow, and we don't know how much it will grow. So you never really know for sure whether there's going to be estate tax due when someone dies. But if you knew, or if you're much lower than the estate tax threshold, the idea there is keep it in your estate. Let everything get a step up in basis. Then your kids will inherit everything. The inheritance will be income tax free, because an inheritance is exempt from income tax unless it's a traditional IRA, and they'll pay income tax on that. But they could sell those appreciated assets right after you pass away and pay little or no capital gains tax, only appreciation since the date of your death. All right. Now, by the way, if you are in that 5 million, and by the way, hey, the likes jumped up from 25 to 38. We're about halfway there. Let's get to 50. Get it on, guys. By the way, if you're under 5 million and single, or under 10 million and married, because of this crazy world that we live in, you're probably not real sure you have enough to live off of for the rest of your life. Because, yes, you have your living expenses, but there may be medical expenses, long term care expenses. Those can be in the hundreds of thousands of dollars a year. So you're probably a little reluctant to do the gifting if you're under 5 million, married couple under 10 million, just because you just don't know if you've got enough to live off of. You worked hard, you saved, you think you do, and you probably do, but there's that little bit of doubt in your mind of, boy, I don't want to give these assets away. I don't want to give up control. I just might need those assets in my future. So those kind of work together. That desire people have to retain control is sometimes, from a tax standpoint, in the family's best interest, due to the fact that you may want to keep it in the estate and get the step up in basis when you pass away. All right, so that's the smaller estate. Small is relative term. All right, up to 40, we're there. Okay, get your friends on board. Let them hit the like button. We're trying to get to 50. All right, the medium estates, the estates maybe between 5 million and 10 million if you're single, and maybe between 10 million to 20 million if you're married. Now, those estates, you don't really have enough. And I know it sounds funny that I'm saying a married couple with $20 million doesn't have enough money. Just, stay with me here, because everything's relative, and so, but I'm going to keep going here. With those married couples with the 10 million to 20 million, you don't really have enough to take full advantage of the anti-clawback rule, because the people who are taking advantage of the anti-clawback rule are using their humongous exemption, currently $13.61 million, during their lifetime. And to use it, you got to give those assets away. So if you're sitting on, a $14 million estate, congratulations. But to fully take advantage of the anti-clawback rules, you've got to give away $13.61 million. You're just left with a couple $100,000 to live off of for the rest of your life. That's not going to make you very comfortable. So you're really not in a position, those single people between 5 and 10 million, married couples between 10 and 20 million, you really don't have enough. I hate to say you don't have enough. It sounds awkward, but you don't have enough to take advantage of the anti-clawback rules. Now, what you should be doing, what you should be informed about and considering, your call on whether you do these things. If you're single and between 5 and 10 million, or married 10 million to 20 million, it's likely that there's going to be some estate tax due when you die. You may only have 5 million on the lower end of the spectrum if you're single. And yes, in 2026, the exemption is going to be $7 million. But if past performance is any kind of indicator of what happens in the future, your $5 million will appreciate, unless you're one of those who says you're spending your children's inheritance. But I find that most people don't spend their children's inheritance. They keep it and they don't like to spend, so it continues to grow. So if you're in that 5 to 10 million single person range, or you're a married couple with 10 to 20 million, even though you can't take advantage of the anti-clawback rules, you probably should take a hard look at maximizing your annual gifting if you're serious about avoiding estate tax. However, I got to tell you, there's this tug of war that people play with themselves when, let's say the individual has, $7 million, and he feels fairly confident it's going to grow over time. And he knows the exemption is going to be in 2026 is going to be $7 million. But he feels, pretty darn sure that in the next couple of years, his 7 million will be 8 million. Few years down the road, it'll be 10 million, may get to 15 million. He knows there's going to be some estate tax due, and he hates paying tax. He tells me, Paul, I got to do whatever I got to do. I hate paying tax. I don't want to pay it. But then we talk about, okay, well, here's what you can do. You've got 10 descendants, you got 3 children, you got 7 grandchildren. You and your spouse can give away $18,000 to as many people as you want to every year. You can give it to them directly. You can put it in a trust for them, so you retain a little bit more control. Name a trustee who will, abide by your wishes and manage all those assets appropriately. And you and your, even though you have 7 million now, but it's going to grow between you and your wife. If you're married, between the two of you, you can get $360,000, 18,000 times 10 descendants, time, and each spouse does that gifting. You can transfer $360,000 out of your estate now, and maybe you do have the $14 million estate because you're married, or maybe you're you're single, you have $7 million. You can do $180,000 of gifting because you don't have a spouse you can do the gifting with. And then this person who's like, I'm going to do whatever I need to do to avoid tax at all costs starts getting a little nervous. And there's like, Paul, what do you mean to tell me? You mean I want to give it away, but I want to control it. But you can't have that mindset. If you want to get it out of your estate, you can't control it. You have to give it to them or put it in a trust for them. You can't get it back under any circumstances, have the right to get it back under any circumstances. So some people you can kind of play this game. They talk a big game about wanting to do what they need to do to avoid tax. But when it comes to the way to give tax is to give up control over assets, it starts to make them nervous. So what's greater, your desire to remain in control of everything that you own? Hence, you don't do even the $18,000 annual exclusion gifting. That's gifting that doesn't even count towards your estate tax exemption. You can do that every year to as many people as you want to. No brainer for purpose, if you're just doing math, no brainer. If you're going to have a taxable estate, no brainer to do the annual gifting, because for every $18,000 that you give away, that's out of your estate, you just save a 40% estate tax. And quite frankly, you saved a lot more than that, because after you give it away, assuming that $18,000 gets invested and it appreciates from the time that you give it away until the time that you die, not only does the $18,000 avoid estate tax, but all of the future appreciation on those gifted assets avoids estate tax as well. So what desire is stronger? Your desire to stay in control of everything that you have, or that desire to stick it to Uncle Sam and avoid tax? So it just depends on your mindset. And look, we're at 47 on the likes. I was like shooting for 50. Got to get 3 more. Let's go. So that's that, the single person with the 7 to 10 million, or the 5 to 10 million even, or the married couple 10 to 20 million. You don't have enough to take advantage of the anti-clawback rules, but you've got to really look at whether you have enough to do this annual gifting. And look, once you start an annual gifting program, you can stop it at any time. You can make those decisions every year whether you gift. But the earlier you start, especially if you start while you're married and both spouses can do the gifting, you can shift a pretty significant sum outside of the estate and avoid that 40% tax, and avoid the 40% tax on the appreciation of those assets after they've been given away. All right, so that's the medium estates. Now let's move to the large. Those large estates, God bless you, well in excess of $20 million if you're single, $40 million if you're married. Now we're really narrowing the group of people that, but hey, it's good cocktail party information, even if you have little to nothing. All right. Now, if you're single 20 million plus, married 40 million plus, now you got to do some thinking, and you need to start to make some decisions, because you do have an opportunity to take advantage of the anti-clawback rules. The $20 million single person has to look, again, what's that control versus avoiding taxes battle that's going on in your mind. But if you look at just pure math, the $20 million person can give away $13.61 million this year, while their exemption is so large. If they don't do it, they're going to be stuck with a $7 million exemption, and a lot more tax is going to be paid when they die. So now, but you got to remember, on all of this gifting, whether it's the annual exclusion gift of $18,000 to as many people as you want to, or you gift assets in excess of that and use some of your exemption, you've got to factor in this. The downside of gifting is the step up in basis is gone. So gifting is a carryover basis. What's the best kind of gift? Probably cash, if you have it. So you gift cash. There's as opposed to gifting that appreciated Microsoft stock. So there is an analysis of what are the best assets to gift if there's going to be gifting. So, but I got to tell you, other than the annual exclusion gifts, which can be a no-brainer from a pure math standpoint, again, they're not a no-brainer from a I'm going to lose control of those assets after I give them away standpoint. But if the decision is to whether to keep an asset in your estate and have it taxed at 40% estate tax when you die, the better decision may be to gift the asset. And even if you're using some of your estate tax exemption, and have those donees, the people that you made the gift to, incur capital gains tax upon the sale at 20%. Capital gains tax at 20% is better than estate tax at 40%. Now, assuming that you use the annual exclusion gifts, a married couple with 10 descendants can gift $360,000 annually without even using any of the exemption amount. So for the wealthy folks, the annual exclusion stuff is a no-brainer. All right, so let me give you a quick summary. We'll head over to the chat. We got 52. Fantastic with the likes. Thank you to everyone. We bumped it up from 25 to 52. Quick summary. First thing that you need to understand, you'll be way ahead of the game if you understand the effect of the sunset of the Tax Cuts and Jobs Act of 2017, which is if you make a large gift, and large is relative, but a gift, let's call it in excess or well in excess of $7 million, up to maybe $13.61 million or whatever the exemption will be next year, then you can take advantage of the anti-clawback rules and use your exemption while it's so high. That doesn't apply to everyone because most people kind of can't financially swing it to be able to do it. Either they don't have that much, or they have a little bit more than that and they're not comfortable giving that much. Now, if you do make a smaller gift this year, 1 million, 3 million, 5 million, you're not really taking advantage of the anti-clawback rules. You're just simply using part of that $7 million exemption that you'll have when you die in 2026 or later. And so, if you too many people are thinking I'm going to give $3 million away now while my exemption is 13.1 million, then I'll have another 7 million in 2026 and beyond. That's just false. Give away $3 million now, you die in 2026, there's only another $4 million that you can give away estate tax free. So be aware of the smaller gifts, you're just using part of your $7 million exemption. All right. Another kind of rule to live by, and it's really an impossible rule, but if you know your estate will not be subject to estate tax, keep the assets in your estate to take advantage of the step up in basis. Now, I realize there are some people out there, not many. I mean, and again, I've had thousands of conversations, but I've had a few who say, Paul, I want to go ahead and do some gifting to my children because not even so much for tax purposes, but because I want to see them enjoy it while I'm still here. I want to make their life a little bit easier. I want to help pay for their children's education. I'd like them not to struggle so much. They're struggling, they're paycheck to paycheck. If I can do some gifting during my lifetime and see them enjoy it, I'd like to do that. So great. If that's what you want to do, great. So there are some reasons to do gifting that are other than just pure tax related. And if that's you, fantastic. All right. So, but if if you're sitting on a $3 million estate, there may never be estate tax. We don't know what Congress is going to do in the future, but really no need to do the gifting, and just keep it in your estate, and which you probably like because that allows you to keep control. And then let the kids get the step up in basis and let them enjoy that. All right. Now, if you feel like your estate will be subject to estate tax, and maybe you have $5 million estate now, $4 million estate now, and you think you're probably going to live 20 or 30 years. I think I'm going to live another 20 or 30 years. I just turned 59. And so, maybe you're thinking, right now I'm stuck at over 7 million. Or you're thinking right now, no, I don't have 7 million, but I probably will by the time that I pass away. That's those people who should consider doing the annual gifting to move assets out of the estate without using any of your estate tax exemption. We've talked about it a couple of times. You, and if you're married, you and your spouse can give $18,000 each to as many people as you want to every year, shifting assets out of the estate without using any of the estate tax exemption. All right, so let's move over to the chat. We got got a lot of highs going on. I love the highs. I like when you say hi to Paul, that's me. Hi to other people, that's fantastic. Hi, everybody saying hi to everybody else. That's great. All right, so I'm going to blow through all the highs, not because I don't like them, I love them, but because we need to get to some substance. All right, to get the step, I get this question a lot. Van Dow, to get the step up in asset, or really step up in basis, I'm guessing is what you're asking. Does it have to be in a trust? Clear answer to that. Does it have to be in a trust? No, it does not. A lot of people ask me, Paul, if I die, what are my survivors? What are they going to have to report? What are they going to have to file? What documents need to be prepared so that they get the step up in basis? And I'm like, nothing. It just happens. If you own the asset when you die, whether it's in your probate estate, whether it's in your revocable living trust, whether you have some kind of transfer on death deed on your home, whether you have some TOD beneficiary designation on a brokerage account or some stock, under all of those circumstances, the step up in basis just happens. Nothing needs to be reported. The new basis doesn't need to be reported to the government. Now, I will say, when someone passes away and the heirs inherit assets, it is really good practice to inventory all of those assets, determine that value of those assets on the date of death, so that when those assets are subsequently sold, whether it's a year later, 10 years later, or 30 years later, you can go back and you'll have that basis, rather than having, boy, what was that 1/4 interest in that privately held business worth when dad died 30 years ago? Now that we've sold it, we've got to report the capital gain. Get all that documented. That could avoid potential IRS problems, could prevent the IRS from wanting to question the basis that you put when you did ultimately sell that asset. All right, good question there. Okay. In fact, Maria answered it much more succinctly than I did. Thanks, Maria. Does the step up in basis for the stock still apply if there's a name benefit? Yeah. I should have read that one first, in which the stock is held at hypocrite stock through a will. Yeah. No, if you have a TOD, transfer on death, brokerage account, TOD, yep, still get the step up in basis. Anne gave me those 3 extra thumbs up. And so that put us over the 50 mark. Fantastic. Thanks, Donna. Can you set up a trust to dodge the 40% death tax? Well, that's a whole nother live stream right there, but let's keep it really simple. If you're going to do the annual exclusion gifting, giving $18,000 to as many people as you want to every year, year after year, yeah, that's a big saver of estate tax. And you can do that by making gifts directly to people or putting gifts into certain type of trusts for them. Are there other trusts that people are using to take advantage of the anti-clawback rule, gifting their assets to trusts now while they can, significant sums of it? Yes, they are. So it all depends on your circumstances. There's many different kinds of trusts. We'd have to talk about it. All right. How does the 3-year clawback rule with personal property gifts other than money? I'm not sure if I'm with you there on that 3-year clawback rule, Michael. As long as assets are included in your estate when they qualify step, then yeah, it has nothing to do with whether or not they are subject to probate. Paul can confirm or correct. Paul can confirm. Yep. Like I mentioned that earlier, when very first thing, you must have been just a couple of minutes late. Very first thing I did was talked about the assets that are in your estate. If they're in your estate for estate tax purposes, then they get the step up in basis. So it has nothing to do with whether those assets go through probate or have a TOD beneficiary, POD beneficiary, or in a revocable living trust. They get the step up because they're in your estate. All right. Chelsea, thanks, Mike. Okay. Have you discussed when a spouse is a non-citizen but a permanent resident with a green card? I haven't discussed it, but usually those discussions start with making sure that if the citizen spouse dies first, assets go into a particular type of trust with a particular type of trustee called a Q dot. The IRS doesn't want wealthy citizens to leave their estate to a non-citizen, and then the non-citizen takes those assets out of the country. The non-citizen dies. The IRS never gets the estate tax that they would have received. So there's some particular rules on that, and there's other rules too for non-spouse citizens. We'd have to, I mean, non-citizens. We just have to go through that. All right, Susie, with some good emojis. I like the pink little kind of 5-finger emojis there. All right, I'm going to catch a breath and call it a day for the live stream. We got the likes up to 58, exceeded my goal of 50. It's the little things in life that make you happy. Got some more live streams coming up. Check the schedule, and we'll see you next time. Have a great day.